Good afternoon, everyone. Thank you for attending my lecture today. I'm Lilian from Treatment Department, and my topic is Madrid System for International Registration of Marks. In today's highly competitive marketplace, trademarks are an indispensable business tool which enables companies to effectively market and promote their services and products. If the business extends to overseas markets, the client usually needs to have its trademark registered abroad. There are usually two ways to obtain overseas trademark registrations. The first one is registered trademark through international organization. Nowadays, there are mainly 4 systems or organizations that are widely accepted in the world. They are Madrid System, European Community Trademark System, African Intellectual Property Organization, and the African Regional Intellectual Property Organization. And the second way is national registration. That means the applicant can file separate trademark applications in each country. Today, I'll give you an overview of international trademark registration system, i.e. the Madrid System. It's a system administered by WIPO as a cost-effective and efficient option for businesses that would like to seek to protect their trademarks in multiple countries. This is the outline of my content. Firstly, I will give you a brief introduction of the Madrid System and about its composition, history, members, and so on. And then I will show you the advantages and disadvantages of Madrid System. And lastly, I will show you briefly how to register an international registration of marks under Madrid System. First, what's Madrid System? The Madrid System for the International Registration of Marks, established in 1891, functions under the Madrid Agreement and the Madrid Protocol. It's administered by the International Bureau of WIPO, located in Geneva, Switzerland. And the system of international registration of marks is governed by 2 treaties: the Madrid Agreement concerning the international registration of marks, which dates from 1891, and the Protocol relating to the Madrid Agreement. It was adopted in 1989 and came into operation in April 1st, 1996. A set of new common regulations were adopted during the 2003 Assembly of the Madrid Union. The new common regulations came in. Important modifications were introduced to the common regulations, such as the inclusion of Spanish as a third working language of Madrid Protocol, in order to facilitate the accession of the European Community to Madrid Protocol. And the system is administered by the International Bureau of WIPO, which maintains the international register and publishes the WIPO Gazette of International Marks. Any state which is a party to the Paris Convention for the Protection of Industrial Property may become a party to the agreement or the protocol of both. In addition, an intergovernmental organization may become a party to the protocol if at least one of its member states is a party to the Paris Convention and the organization maintains a regional office for the purpose of registering trademarks. From 2007, there are 18 members comprising the Madrid Union of Jurisdictions, 49 bound by the agreement and the protocol, 8 bound by the agreement only, and 23 bound by the protocol only. The primary reason that why the protocol is more popular than the agreement is that the protocol introduced a number of changes to the Madrid system, which significantly enhanced its usefulness to the trademark owners. China also became a member of Madrid Agreement in 1989 and then a member of Madrid Protocol in 1995. Two significant recent developments in international trademark system were the accession of the United States and the European to the Madrid Protocol. With the addition of these jurisdictions to the protocol, most major trading jurisdictions had joined the Madrid system. Next, I will show you some terms of Madrid system to facilitate understanding. The first one is contracting parties. State parties to the agreement and/or the protocol and organizations parties to the protocol are referred to collectively as contracting parties. The second one is Office of Origin. Trademark office of the contracting party with which the applicant has a necessary connection through establishment, domicile, or nationality. WIPO means World Intellectual Property Organization. And basic registration or basic application. That means an existing trademark application or registration owned by the applicant in the Office of Origin. The designation or subsequent designation. An international application must designate the contracting parties in which the mark is to be protected. The effect of an international registration can be extended to a contracting party not covered by the international application by filing a subsequent designation. Thus, the holder of an international registration can expand the geographical scope of the protection of his mark in line with his business needs. Based on the above basic introduction, I make a table here including some comparisons between the Madrid Agreement and Madrid Protocol. And the first one is the history. The agreement has a much longer history than the protocol. And the second is the membership. And the protocol has a broader member, also including the intergovernmental organization than comparing with agreement. And the third is the premise for filing an international application. Under the protocol, it's possible to obtain an international registration based on a pending trademark application or a registration. By comparison, the agreement requires that the trademark owner already holds an existing registration in the Office of Origin. If the international application is governed exclusively by the agreement, it must be filed in French. But if it is governed by protocol or both the agreement and the protocol, it may be in English, French, or Spanish.